Initially, you need to consider if a license is necessary and which categories to apply for. Do you apply for Tier 2 General, Tier 2 Intercompany Transfer as well, and also a Tier 5? You need to think about that, because if you haven't done it with the initial application and you suddenly decide that you need to do a sponsorship for, say, for example, you did a Tier 2 General, but then you need to do an ICT, you're going to have to go through the whole application procedure again and face further audits, etc. Once you've decided that, you then need to nominate your key personnel, the authorizing officer, key contact level 1 and level 2 users. As legal advisors, we would recommend that your level 1 and level 2 users also include legal representatives, primarily because they help and support the level 1, level 2 workers in-house in terms of when there's issues with the sponsorship management system, or to even deal with when was a change of staff internally at your organisations, or there's someone off on maternity or an annual leave at the time when you need to be making a sponsorship application for a Tier 2 certificate. Once you've decided all that, you make your online application and pay the fee. The fee currently for small businesses is £500 and for large businesses £1,500, and that also is applicable for extension applications. You will then submit your supporting documents to confirm that you are a properly trading business, and if you're relying on copy documents that you're sending, you must ensure that you keep the originals of those documents, because they will be asked for during an audit. You're then likely to get either a pre-registration UKBA visit. What the UK border agencies say is that if you don't have a pre-registration visit, you're likely to have a visit within the first 12 months of your registration, though they say that we're registered as sponsors and we actually had our visit in year 4 of our registration, so it took them 4 years to get around to us. But you know, you just don't know what sort of strategy they're using there, or you know, what hit and miss policies they're using to confirm whether you're going to be audited pre-registration or post-registration. So the key is just to be ready for an audit at any time. Assuming all goes well, you'll then give an entry to the sponsor register, and you have access to the SMS, and you can issue certificate of sponsorships. During an audit, the UK Border Agency are going to focus on 5 things. The first thing that they're going to look at is that you are monitoring immigration status and preventing illegal employment. As we go through these 5 areas, you know, really think about your own business in terms of, you know, yes, tick the box, we're doing this. If you're not doing it, asterisk it and go away and, you know, immediately put a system or a process in place. If you feel that you can do it better than what you're currently doing and you need the support of that, again, mark it up as we go through this, because this is really the area where a lot of employers are falling down on in terms of their 5 areas of responsibility. So as I say, the first one is immigration, ensuring that the person has the right to work. In February 2008, when the sponsorship system came into play, the UK Border Agency also introduced 2 penalties. The first one was the criminal penalty. This is when you knowingly employ someone who you know does not have the right to work in the UK. I know it's not going to apply to any of you, but you know, should that situation happen, and it is happening, people who do that face prison for up to 2 years and or an unlimited fine. It's only directors and owners of business who can be sanctioned under the criminal penalty. The civil penalty is the one which you need to be more aware of, and this is where your recruitment policies are negligent because you do not check the right to work documents before a person starts to work with you. Not the first day of employment, not during the first week, not during induction, not you've got an audit so you quickly have to get everything in order, but you now must, since 28th of February 2008, make sure that before a person starts employment with you that you have the right to work documents. Failure to do so, if it's a non-EU worker, you're looking at maximum fines of up to £10,000 or £5,000 if it's an A2 Bulgarian or Romanian worker. The penalties are issued there and then at the time of the audit. You do have 28 days to appeal the decision, and it's worthwhile looking at that because, again, the UKBA are known to get it wrong on occasions. If you cooperate during the audit, during this time when the UKBA are considering to issue a sanction, issue a fine, you may be subject to a sliding scale. And again, certainly that's something that happened with Tesco, who were asked by the UKBA, once they found that who the illegal students were, to allow them to continue to work there illegally until the UKBA could act properly and basically lift the student workers at that time. Yep.
That's a question on that. If you as an employer are transferring employees in, and during the due diligence or the 28 days that you have, the previous employer perhaps hasn't done that, are you still eligible to take that one?
In that type of scenario, so basically you've taken over a business,
Yeah, and you discover that perhaps...
and there's a 2P situation that's happened.
Yeah.
If you've discovered that the previous employer has failed to do something, you won't be sanctioned for that. But what you will be allowed to do then is to rectify the situation so that the migrant worker can work for you properly. Does that help? Okay.